Welcome everybody to another one of our WIST webinars. My name is Serena de Freitas and I shall be your host for today as Marina is on a much deserved break. Before we start, I'd like to thank our sponsors. They wonderful, incredibly supportive. Without you, we wouldn't be here. ZD Fin, Sectional Title Solutions, We Connect You, PKF Octagon, and Multiprop. And today our guest is the esteemed advocate Frank Stanley, the founder of ADR Access and ADR Ubuntu. Welcome, Frank, and thank you so much for partnering with WIST on this amazing alternative dispute resolution platform. So let's dive right into it. I've got some questions for you, and I'm sure everyone wants to know the same thing. So, Frank, we know you're an advocate of the High Court. Tell us a little bit more about yourself and why have you decided to move away from litigation towards mediation?
Yeah, Serena, before I answer your questions, I want to say good morning to everybody. I'm here at this in the sunny Western Cape, George, Knysna area, beautiful today. Yes, thanks for inviting me to this webinar. And to get back to your question, obviously, I've been practicing law. I don't want to give my age away, but I've been practicing law. I've been an admitted advocate since '96, and obviously, I've been before that for 10 years. I was at the Department of Justice. I specialize in a variety of forms of law, obviously criminal labor law, a lot of commercial law, and in the last, I would say, 15 years, I've been a mediator, I've been an arbitrator, and obviously, alternative dispute resolution is a passion of mine. And I would say about just before COVID, I got extremely frustrated with the law, in the sense matters being postponed and not being tended to. And then I started developing ADR Access, which is obviously an arbitration platform, which was launched around about 18 months ago. And and then we started working on ADR Ubuntu, and we launched that around about 2.5 months ago. So it's obviously I've got a passion for sorting things out quickly, as cheaply as possible, as confidentially as possible. So hence all these platforms were born.
So we know that CSOS does adjudication. So what is the difference between mediation and adjudication in terms of what the platform offers that CSOS doesn't?
So I think obviously the difference between the two platforms, obviously, first of all, CSOS is just obviously not just an adjudication platform. They also offer conciliation in certain cases. A conciliation process obviously followed then by adjudication. In some matters, obviously, the matter from an application stage can go immediately in an adjudication stage. Obviously, with CSOS, it is very obviously when you look at the directives, which I'm not going to go into detail, the practice directives, they advise people to follow the internal processes in trying to resolve disputes before coming to CSOS. So when it comes to mediation, ADR Ubuntu, so mediation is very brief. It's when people have disputes, they invite a third party into the dispute to help them resolve the dispute. The third party doesn't make a decision. It just helps the parties resolve the dispute. And if it is resolved, an agreement is drafted, settlement agreement, and is signed by the parties. When it comes to adjudication, specifically to your question, it is when a third party gets invited to the dispute, who's an adjudicator. He then listens to the parties and then makes a decision on behalf of the parties. So the difference is one side we help parties resolve the dispute, and in the other way, from an adjudication perspective, an adjudicator gets appointed, listens to the parties, and makes a dispute on their behalf.
I understand. And I believe the courts today, they require that you set up the mediation process prior to the hearing.
Yeah,
how does this work and why are the courts going this way?
So obviously there's been a tendency to make justice more accessible to people. And obviously, from a court management perspective, their court roles, they obviously want to minimize the matters that go to hearing. Hence, what then transpired is, through legislation, they call it voluntary court annexed mediation, is then when you start litigation and in any stage until you even judgment stage or just before judgment, parties can refer the matter to mediation. So there's been a very big tendency to utilize mediation as a form of resolution before pursuing litigation. And obviously it's in legislation, and there's a numerous amount of forums out there that recommend mediation even prior to a litigation phase. Obviously, the quicker you can get to a mediation platform, the cheaper and more efficient it's going to be at the end of the day to resolve a dispute.
And in the
that answers your question.
Yes. In the commercial environment, do you see mediations on the rise, especially with your other platform, the ADR access, and what kind of industries use this platform?
So obviously, there's a big difference between the two platforms. We've got ADR Access, which is an arbitration platform, very similar to adjudication, where we appoint a third party as an arbitrator to hear a matter and to make a decision. On the flip side of that, we've got ADR Ubuntu, which is a mediation platform, which is very then similar to conciliation. So where you have a third party coming in, helping the parties resolve the matter. So yes, there's been a huge shift, if I can say, within the commercial environment, where people are looking at resolving things before they get to litigation, and obviously the mediation route, hence the court annex mediation as processes after a person has filed or started the litigation process. So there's a big move towards it, but we're sitting in a legal fraternity that is very conservative. So although there's a big move towards settling matters or negotiating or mediating prior to litigation phase or during, it's been a very slow process of getting people there, purely because of one big thing, is that people need to agree. There needs to be consensus between the parties, either from a mediation perspective or an arbitration perspective. Parties need to consent to the process before it can go there. So in a lot of times, in most matters, or in a lot of matters, you're getting the one party kicking for touch, winning time and hoping, causing a lot of delays because of the legal processes in place. That is admitted. And in doing so, hoping that the other party is not going to continue with the litigation process. Like I say, however, there's been a huge shift within the legal fraternity, within the judiciary, of advising people to follow ADR routes. And lately, there's been a lot of court decision where the counsel and the attorneys have not been paid their costs, because the judges felt that they should have pursued an ADR mechanism before coming to court.
Yeah, that's interesting.
And in some cases, attorneys have been held personally liable for the costs of a matter because they did not pursue mediation beforehand. So there has been a shift, but sometimes shifts are a process within our legal fraternity.
And now, if we look at community schemes, I mean, obviously the exciting news is that ADR Ubuntu has joined forces with Women in Sectional Title to create this new online mediation platform. But how did this come about?
So obviously, from ADR Ubuntu was always part of the plan of initiating it and launching it. Prior to that, I realized, because of my involvement in a lot of litigation processes involving sectional title issues, from a behavioral issue to a arrears event issue to far bigger issues. And I identified this market as somewhere where mediation could really be of value to people, offering an alternative. I then obviously met Marina, who is one of the gurus when it comes to sectional title matters in our country. She's got a passion for sectional title. We started having conversations, and this is about a year ago already, looking at alternatives, seeing where we can add value to what there is already in place. There is legislation in place, CSOS is in place. The reality is, where can we add value to all these processes and most of all, to the public out there? Hence, the collaboration with Marina and Women in Sectional Title.
And can anyone who has a dispute in the community scheme use this platform?
Anybody can. It's just not a platform just for women. Obviously, ADR, Ubuntu, we deal with a variety of disputes, not only sectional title, any form of dispute, from family matters to criminal matters, to civil actions, claims for damages, lease issues, disputes. So yes, and anybody can come. Obviously, the benefit of our platform is that you need to obviously register a profile before you can register a dispute. Once you register a profile, it's free of charge. You can even register a dispute, which is also free of charge. The billing only starts once the other party, which we call the respondent, says, I'm happy, let's proceed with the mediation process on the platform. Then only the billing starts.
And then now, obviously, you mentioned both parties need to agree. So that's the crux of it. And then who are the mediators?
So obviously, I've got a variety of mediators. At the moment, I've got around about 180 mediators on my panel, ranging from ex-judges, senior advocates, junior advocates, senior attorneys, junior attorneys, people that are experienced, obviously, in sectional title. We've been very fortunate. Marina has identified several very strong mediators, female mediators, who are also part of our panel. So our panel stretches quite wide when it comes to experience and the nature of matters we can tend to. And obviously, one of these being sectional title issues.
And who pays? I think this is the one of the main questions that we would get from the audience is who pays and what is the cost? So
obviously, when it comes to costs, the biggest motivation of the cost factor lies in the expediency of getting the matter in front of a mediator as quick as possible. Hence, the decision was made that the applicant, the person complaining or lodging the dispute, will carry the initial cost. So obviously, that then can be alleviated at a later stage should an agreement be reached between the parties in a settlement agreement, where then they can also then address the cost issue, where they can agree. But although the applicant has paid initially, we can then share the cost, or the respondent will carry the cost, because obviously the applicant has lodged the dispute because of the respondent's action, may it be because of arrears, levies, may it be behavioral issues, whatever the case may be. The reality, the applicant always carries the cost. And from a sectional title perspective, I think in order to ensure, because we're all about expediency, it's about getting a matter in front of a mediator as quick as possible and dealing with the issue. Obviously, there's a cost element attached to it, which there is not when you go to CSOS, because of the fees that people are continuously paying towards CSOS. But the reality, when it comes to expediency, it's quick to register profile, free to register a dispute, respondent agrees, applicant gets held responsible for the cost. Obviously, from a cost perspective, we've got a cost structure built into ADR Ubuntu. Obviously, if it's a dispute relating to money and the money is fixed, there are various amounts of costs involved, ranging from 0 to 50,000, etc., etc. If it's a non-pecuniary issue, could it be a behavioral issue of somebody? Then obviously a cost will be negotiated. However, from a sectional title perspective, I have negotiated a set fee with Marina. I've spoken about it. We've spoken to many parties about it. We've spoken to mediators, a variety of body corporates, and what we will do is we will curb the cost. We will fix a cost when it comes to mediation matters for body corporates. It will be fixed at 1,500 Rand plus VAT. That will include the dispute, and it will include the costs of the mediator involved per day for the dispute. And we assume most disputes will be finalized within or mediated within an hour or two. So we will fix the cost, so everybody will know what the cost is up front, with no surprises.
That's great. So that's fixed no matter how complex the case might be or how simple the case might be. This is a fixed cost.
It's going to be a fixed cost. And what I do want to add is, I think by the end of this month, we will also be launching various specials to the body corporates, which will most probably entail register your profile and you'll get 25% of your first dispute, for example. And then we'll obviously put a little package together where you can have 3 disputes for an X amount of money at almost like a 40% discount. So that it's like going to be a launch special, let's call it such.
Yes.
We're going to accommodate people up front. Look, the purpose here is to make justice truly accessible for people, number one. And number two is to ensure that there's some form of expediency. Why we focus on expediency is very, very simple. Is that, and this is out of my 30, 40 years of experience, and I've been involved in many sectional title disputes. I mean, I've been involved in a dispute which has led to one owner literally shooting another owner, killing the person on site. I've been involved in owners actually having physical altercations with one another, people landing in hospitals. That's how serious things can become. And my take on this is, the quicker you can address an issue, the better. Because the problem is, once it gets built up, frustration, and people start getting bitter. The longer something gets to sort out, people start getting bitter, and emotions start getting the best of everybody. Which in itself then means, doesn't matter where you go to, if it's a court process or a CSOS process, people are very apprehensive to sort something out. So it will go the full hog in the sense of CSOS matters. I mean, I'm sitting with a matter right now where it took CSOS around about 11 months to appoint an adjudicator and 5 months for the adjudicator to make a ruling. What we're talking about, 16 months. In the court situation, our courts are full, and you're not going to get to court, even if it's in the magistrate's court, within 14 to 16 months, if you're lucky with a trial date. So, and our processes are very easy, quickly. You lodge your dispute, within 3 days, the other party responds. Within 7 days, 7 to 10 days, we appoint a mediator, and off we go.
Yeah, I think because the longer you leave things, the more they fester, and the less it becomes about what the actual issue is. And it becomes more personal, you get egos involved. And it's almost like by the time you have an adjudication, it's so long, or by the time it's heard in court, it's been so long, no one wants to give an inch. And there's less likelihood of mediation working unless it can be done quickly. And I think that's your point.
Well, that's the focus, and it's not always just, people might say, but everything is for free at CSOS. Free is a relative concept. And when you start attaching time to costs, the longer something carries on, the costlier it's going to become on a variety of levels, emotionally, psychologically, and financially. So, look, I believe CSOS is there for a reason, and we are there to support CSOS. Hence, We are there to
Absolutely.
say, listen, CSOS is telling you, don't come to us until you've resolved the matter or attempted to resolve it yourself. Hence, we've put in something in place that is objective, that is managed by highly experienced people, that is affordable. And it takes away, it moves the shift from a body corporate saying, obviously because they're going to try and negotiate something initially, and once they cannot negotiate, to pass it on to an independent third party to sort this out. And I can guarantee you that in most cases, you are going to resolve the dispute, provided, obviously, and the experience of the mediator is very, very key to this process. So we believe that 80 to 85% of matters should be settled. And if it does go further, you do a proper minute, which you then file with your application to CSOS, where the issues have been sorted out, common cause issues and issues in dispute. So if you file your application to CSOS and you've got a proper minute and you determine this is the only issue that must be argued, can you understand what's going to happen? So when CSOS receives it, usually there's an investigation and an assessment and whatever takes place before an adjudicator gets appointed, and then they go into their own process. Can you imagine how it's going to shorten the time at CSOS when CSOS receives a proper minute drafted by an experienced person saying, listen, parties have agreed to X, Y, and Z. They only disagree with A and B.
Yeah.
What's going to happen? It's going to shorten the adjudication process within the CSOS environment tremendously.
Yeah.
So there is an advantage and a benefit. And because the pricing is reasonable and structured, you know what you're in for from the outset.
And what types of disputes can be mediated? And I understand that you are quite in favor of having arrear levy disputes mediated in this way as well.
Any dispute, the fortunate thing about mediation, anything can be mediated, anything. So from a sectional title perspective, it could be arrear levies, it could be a behavioral problem, it could be a problem you've got with the body corporate, it could be anything. Any dispute can be mediated. Obviously, when it comes to an arbitration, it's a little bit different. However, like we say, we are here to complement and to add value to what is already in place. And I think if we can sort out what goes to CSOS, and whatever then goes to CSOS is properly minuted, we know what is in dispute, will help them a hell of a lot from their process perspective to actually adjudicate the matter. So we're complementary. We're not there we're not there in an adversarial capacity. We're not there to fight against what there is. We're there to complement what there is. If that makes sense to you.
Absolutely. And we know that when we go to CSOS, the process is they will set down a date for conciliation first. So that will take a while. In conciliation, obviously, the conciliator will listen to both sides, but won't actually, in my experience, won't actually recommend a solution. They kind of ask both sides what they want out of it, and then hopefully it results in some kind of conciliation. In my experience, I haven't had any successful conciliation where there's been no direction from the conciliator. They're just there to hear both sides in terms of what CSOS does. And then CSOS will obviously then set once that doesn't work, it will then go to adjudication, where that would be held now and dealt with on the papers. So in the event that now we can go to this mediation platform first, we can then show that we have, like you say, looked at all internal resolution options. We've tried to solve the problem internally. It hasn't worked. Here is the result of the conciliation or the mediation. And therefore, can CSOS now say, let's go straight to adjudication avoid the time that's going to take to now set another conciliation date.
So you've spoken about a lot of things there, Serena. Just to answer your last question, the reality is, CSOS is governed by legislation and their own directives. So they've got processes in place.
Yeah.
And they saying to everybody through the rules, listen, come to us once you've exhausted your own processes. However, as a caveat, they say, if you come to us, but remember, once you put you lodge your application, there's a whole assessment. Should it be there? Should it not be there? And that takes time. So that takes 14 to 21 days. Then they decide, but listen, these guys haven't either one, fulfilled their own internal processes, or there's no internal processes, so we refer it to conciliation, which then takes process. Remember, by that stage already, you have filed your application. The respondent, once they decide, but okay, we can, after an assessment process, we can hear the matter, then it takes 14 days for the respondent to file their opposition to the application. Then the applicant gets another 10 days to file their response for what the respondent says. But now, how much time has gone by? 5 weeks, 6 weeks? Now we're saying, okay, must we go to conciliation? Obviously, conciliation route is different. When do we do it? How do we do it? Who do we appoint? After that, then the adjudication route. So once again, those are their processes. So if we mediate the matter prior to it reaching CSOS, CSOS want people to do that. They want them to follow the internal process. Our challenge is for the body corporates and the people out there, which I think a last calculation, there are about 60,000 body corporates in our country, or sectional title. Our challenge is for the sectional title of the body corporates to engage with us, to implement mediation processes into their structures, may it be at a trustee, as a trustee directive, or at the AGM, or part of their rules, or even by agreement with the parties. So that's the challenge. And that is what CSOS wants. So if it does go through mediation and it is successful, happy days, you don't have to go to CSOS. However, if you aren't successful, you can still do a mediation minute, like I said to you before, which then says common cause, issues in dispute, then refer it. It's going to be a quicker process for everybody involved. Yeah. And quicker means less frustration, less bitterness, and at the end of the day, spending less money.
But I think the important point is that we are here to support CSOS, to complement the process that CSOS already has in place, so that it can be more expedient. It should relieve some of the work from CSOS as well. Well, in the event that this work, that the mediation is successful, before having to go to CSOS.
100%, and that's the prime objective here. To encourage body corporates, sectional title owners to say, listen, ADR Ubuntu is there. We're a mediation process. We're efficient. We're affordable. It's confidential. And our mediators are highly experienced people. We are there for you. So let us help you.
And unbiased. I think that's
of course, that's important. I mean, every single mediator, once a matter gets allocated to them, they have to sign a form saying they don't know the parties, they are completely objective, etc., etc. So when we do appoint a mediator to tend to a matter, they have to. There is a process involved before I appoint them to hear a matter.
And so, sorry, if you could just say again, so how long will the mediator take to hear a dispute once it comes to you? And is the outcome binding, and do the parties have to sign anything?
So in a nutshell, the process works as follows. An applicant comes online, they lodge their dispute. All right. SMS, emails get sent to the respondent. The respondent gets a link. He clicks on the link. He creates his own profile, which then per se, because you're not going to click the link and continue if you're not happy with the process. Because the email says, this person's laid a dispute, etc., etc. They want to use ADR Ubuntu as a tool to resolve the matter. So once they click on the link, then they can file their response. So they got 3 working days to make a decision of continuing. However, if it's already part of the body corporate rules, or it is a directive, or it's decided that the AGM, this is the internal process, it is automatically, because they've already agreed to something. If it does happen, they've agreed to ADR Ubuntu. So the process will then follow through. The applicant will make the deposit. The registrar or the allocated person will then talk to the parties and determine a date. Our preference is to have the matter before a mediator within 7 working days. So once the respondent responds, files their papers, 7 working days, we want to appoint a mediator to the matter. How long that then takes is up to the mediator.
Yeah, that is quick.
But by that stage, just remember, once you file, the applicant files their dispute. They say what it is. If there's documents to be attached, they attach the documents, and you don't need a lawyer. You don't need to be a lawyer. This is an informal process where you file what you think is necessary, irrelevant if it might not be admissible as evidence at that stage of the process, because you're filing what you're filing your case. And then the other party files their response. And all of that gets, once I appoint a mediator, all of that information gets sent automatically through the system to the mediator. And the mediator then has already got access to the information. We set down a date and off we go. And like I say, the idea is to have it heard within 7 days.
Yeah.
You can have an attorney involved if you want. You can have, we don't have a problem having legal representatives involved because it just helps make the process a lot faster.
And that agreement that's signed afterwards, if it's signed by both parties, is that binding?
Yes, of course it's binding. So there's a settlement agreement which is binding.
Yeah.
And within the settlement agreement, you deal with a variety of issues should a person not honor their side of the agreement. So that could be a referral clause, you refer it back to court to make an order of court. It could be referred to arbitration, depending on the nature of the dispute and what the parties agree to.
And apart from the appointment of women mediators, what is the vision for ADR Ubuntu in respect of future training of mediators?
So we are busy talking to a variety of other parties involved in the sectional title industry. I don't think it's appropriate to say who they are at the moment, but they are big players. They're highly invested within the industry. We obviously want to start talking to variety of important players. The idea is to start training up people to become mediators. Obviously, starting them off at a stage and then working them through. You might not necessarily have to be a legally qualified person, but you could have a passion for sectional title. And we are going to have workshops. We're going to start training people. Obviously, that's going to happen in due time.
That's wonderful.
And really obviously there we will obviously, like Marina's one of the leaders, she's surrounded by a lot of strong female leaders. And we are in the process of putting something together with a couple of other interested parties, key players, to start training people within this environment to be mediators.
And now there's a couple of questions that are on the chat. So I
Yes.
just want to start reading those so we can have
Let
time.
me also let me go to the chat.
Yeah, so after mediation process is concluded and an agreement has been reached between both parties, what will you do if the owner just ignores the agreement and carries on with non-payment? For example, this is a levy question.
So obviously, if there's a settlement agreement in place, this settlement agreement, you can enforce it by depending like what's in the. So you can deal with the enforcement of somebody breaking the agreement, not acknowledging and sticking to the agreement, or if there's a breach. So there's a variety of routes you could follow. You could follow an arbitration route. You obviously could follow a CSOS route, or you could follow a litigation court route.
Okay.
To enforce the order.
So it's sort of like it has the same weight as an adjudication order then, so it can be made an order of court.
Well, there's a lot of difference of opinion pertaining to that. But yes, it can be. But you just remember, from a CSOS perspective, their adjudication and the adjudication orders or the conciliation orders, they've got a specific legislative process, which it is seen as an order of court, but in order to enforce it, you still have to go to the High Court. Yeah. So there's always that you still have to go somewhere else to enforce it.
And then there's a question from Bev. Do you collate the information with the trend of the most common disputes? This will obviously assist CSOS as well.
So yeah, obviously, once we start getting in the disputes, we will obviously start collating and look at the nature of the disputes and train the people accordingly, if that sort of answers the question.
And then Marion said, can I lodge a sectional title dispute today? Are they ready for the mediation of a matter between an owner and trustees or managing agent for making financial decisions, not according to the Act, and do not provide documents on request?
We are ready to rock and roll. The reality is, remember, it's all about consensus. The parties to the dispute need to consent to the process. What we have built into our system, even if there's no consensus initially, you can lodge your dispute. The respondent receives everything. And you'll see when you lodge your dispute, it'll say, have you got a clause or is there a prior agreement? You'll say no, for example's sake. So then our system reads that and then sends an email and an SMS to that person saying, listen here, this person's got a problem. They want to sort it out. They want to use ADR Ubuntu. They're paying for it. It is a mediation process. It's a non-binding process if there's not an agreement used. Come to the table. The person clicks on the link and off we go. We've got the consensus. Alternatively, if people do a mediation agreement, on our website, there are samples of mediation agreements which you can download. People can fill it in and off you go. So it's either or. So we are ready to assist immediately.
And then Kogi said it would be nice to have workshops for trustees so they know the process of CSOS, as some trustees do not understand the process and expect the managing agent to have a resolution in a month for outstanding debtors. Yeah, I think that would probably be something that WIST could probably look at in terms of another webinar altogether. I think the whole process of
we have spoken about this, Marina and I. She's obviously away now, I think for another week or two. And one of the things we have been discussing is to have exclusive workshops for managing agents and or body corporates, where they can attend, engage. That's the idea. Yes.
Yeah, that would be great. I mean, to learn the process. I think that's the main thing. I think a lot of the managing agents kind of get battered because the trustees don't understand the processes and how long it takes to go to CSOS. And some of them think, we're just sitting on our hands and we're not following up or doing anything about it. But, it is unfortunate. It does take long. And like you say, things fester.
Well, here's the solution. We're offering that solution now. You know,
Yes,
that's the
exactly.
solution with us, is that you're handing it over to a third party
Yeah.
who's experienced, who understands sectional title, and they will be dealing with it. You know, once the process starts, believe you me, once we've got 5, 6, 10, 15 matters through the system, it's going to change the face of how people deal with issues. And it's going to be a huge crutch and a benefit, especially for managing agents.
Yeah, I know. I mean, for instance, I think that there's a perception from owners that if the managing agent gets involved and tries to sort of conciliate between the owners and the trustees, they are always going to agree with the trustees.
Well, they
And
shouldn't conciliate. In any case, the reality is a mediator and or conciliator, because it's very much similar. They're similar.
yeah,
Because they're appointed as a third independent party. Independent is the key. So if a body corporate is paying a managing agent, they are not independent. Remember,
well,
they're not independent.
and the
They'll never
managing
be
agent,
independent. So
yeah,
what they can do is, you know, if you're a purist when it comes to terminology, they can maybe help negotiate, but
and
not
then
mediate or conciliate, because you need a third independent party to help the parties come to a resolution.
the Tessa mentioned, could this work for HOA, or was this only between a sectional title?
Any dispute.
So even if the constitution of the HOA doesn't specify mediation, anyone can go to mediation.
Just remember, the fact of the matter is, we understand that the rules have been drafted, that constitutions have been drafted, etc. But the reality is, and we understand, to change rules is a process. Because why? Because CSOS is involved. Okay? It's a process getting your rules changed and accepted, etc., etc. However, you know, that's why there are trustees. They can issue directives. There's an AGM. So your internal dispute resolution process can fall outside the parameters of rules. So it can be, when you've got people voting and they vote accordingly. Now, obviously, the decision is it what type of vote do you need? But the reality, once you've got the people see the advantage of the system, they will vote it in, and you'll be able to utilize it. Alternatively, even if there's nothing agreed to prior, the process, if you follow our process, people can agree to something after the fact, provided when the dispute is handled, that there is consensus. When it comes to mediation, it's best to have it in writing, but it can be verbal. When it comes to an arbitration process, unfortunately, the law says it has to be in writing. When you get the consensus is a different story, provided the consensus is in place when the mediator or the arbitrator hears the matter. If that sort of explains it a little bit to you.
Yeah. And then I just wanted to check if anyone else had any questions. Yeah, from Bev. Poppy has become a deflection for keeping owners in the dark or literally muzzled. How does ADR deal with this, and what is your take? So obviously, going to mediation to ask for documentation that a managing agent should be able to give to the owners, where a lot are hiding behind Poppy, as are trustees. We know this.
Well, there's a variety of ways to get this information. The reality is that, unfortunately, mediation is a consensual process where you help people. If they can't reach a decision, it goes to litigation, CSOS, courts, or whatever the case. So if you've got a very experienced mediator and the respondent comes to the table, you know what the case is. If they're not answering to the case, the question is, why aren't you answering to the case?
Exactly. Yeah.
So, and remember, why is a body corporate there? The body corporates are made up of the owners, and the managing agent follows the direction and the mandate provided to it by who? The body corporate.
Represented by the trustees.
100%.
Yeah.
So at the end of the day, there should be, in most cases, a general consensus when it comes to sorting something out as quickly as possible, so that it doesn't spill over into 5, 10 other issues. And the beautiful thing is,
see, I'm in it.
so the beautiful thing is that the body corporate will be paying, and that expedites the process.
Yeah.
And we appoint the mediators. There's not going to be a debate on who's going to hear it. All I need is my mediator to tell me, I don't know these parties. I'm objective, because in any case, they won't be on my panel if they haven't got some form of standing or credibility.
Yeah. And are there any other questions? Well, I wanted to mention the 3 Ps. Obviously, that's going to be a lot in terms of the mediation. It's going to be the people and the pets and the parking. I think we all know that.
Whatever. Just remember an issue about, I just saw an issue about a cat could be a far bigger, or a dog or an animal making a noise, or what. It could be far more, it's an bigger emotional issue than a levy issue, for example.
Yeah.
But you need the right heart. You know, when an issue comes up, I know who's got the right heart for a matter. You need somebody when it comes to mediation, it depends a lot on people's skill set. So, the purists know that there's various types of mediation: transformative, facilitative, informative, evaluative. So those are processes where you've got a very experienced guy who's sitting. He's going to approach him and say, listen, this is my opinion. This is what the law says. Let's get to it. Another person, if it's an animal issue, I could appoint somebody who's got more of a listening approach. Let's listen to the parties. Let's find a softer landing. And that's the beauty of mediation. There are various styles that can be implemented to reach what? The objective is a settlement.
Yeah.
And
then somebody mentioned, which I think will be the last question, about, they might have missed earlier, about can the dispute be anything like freehold? Can it apply to freehold or only sectional title? And I think you've answered.
Remember, we're talking about mediation is a ADR, alternative dispute resolution mechanism. So we can do anything about a property, from a lease agreement, business, a private lease, whatever it can be. We're obviously just focusing with Marina on sectional title because she felt there's a need. She felt that we needed to support what there is already in place and offer this to people out there. That there is something else out there that's not standing and fighting against everything else, but we're there to assist, and we can assist in record time.
Thank you, Frank.
You don't need an assessment period of 6 months. The facts are the facts, and these things can be sorted out at the first meeting if you've got an experienced person dealing with it.
Agreed. Thank you, Frank, so much for your valuable time.
A huge pleasure, man.
And to all our listeners for attending as well. There is so much to talk about, but unfortunately we've run out of time. If anyone has any questions, they can please direct them to Marina at bbmlaw.co.za. I think Lola has already made mention of that somewhere in the chat, but it's Marina at bbmlaw.co.za. And
Serene,
yes.
If I can also say, people are welcome to go to our website, adr.ubuntu.co.za, or to Frank Stanley on LinkedIn. We've posted all the documents, our collaboration, a lot of detail is there. Please, if they want to send me an email, they're also welcome to do it. I know Marina's out for a while, so if they need an urgent answer or want to refer something, they're welcome to give me a call.
Thank you so
I might not
much.
always hear what you want to hear, but you can give me a call.
That's the story of our lives. We don't tell people what they want to hear. We tell people what they have to hear. But thank you so
Precisely.
much, Fran. Thank you. And to
Thank
everyone.
you very much. Oh, thank you guys for inviting me. It was a privilege to talk to all your people. And hopefully we'll be promoting and marketing a lot of things, upcoming things when it comes to offerings and pricing and et cetera, and other workshops, obviously.
Thank you. That's great. Thanks, Stanley. And cheers, everyone. Have a fantastic week ahead. And maybe a productive one.
Thank you very much.
You'll see Marina probably next month, and it will be Women's Month next month. And don't forget about the NAMA conference as well. If you go onto the NAMA website, the conference is in October in Durban. Thanks, everybody. Take care. Bye-bye.
Thank you, Serena. God bless. Bye.
Thank you. Bye.